Judge, can you hear me?
Now I can. Good afternoon.
Good afternoon. Okay, I saw your mouth moving, but I couldn't hear you. So, okay.
There's something called a mute button that I forget some.
Oh, okay. How about that? Well, while I have you on here, Your Honor, your reset date for the SAP calendar is going to be April the 31st, and that's for everybody else.
Okay.
Okay?
There a 31st for April?
Oh, you know what? I'm glad you mentioned that. Let me look.
Nope.
No, how
It's
I
going to
know the
be
last
May 1st. How
So it'll
about
be
that?
May 1st. Yeah.
May 1st. I apologize, everybody. I guess I just wanted to invent one.
There you go.
I have an announcement.
Okay.
Yes,
I just sent over a dismissal on Sabrina Autry.
ma'am.
Okay.
She's position number 1.
On the regular calendar, did everyone get the add-on?
I am looking at it now.
Okay.
Yeah,
Thank you.
just printed that. Send that to me. I'll find it real quick.
Similar to you, Your Honor.
She said she sent a dismissal.
Oh, okay. So position 1 is no first. Okay.
Thank you.
Excuse me.
Yes.
Hi, how are you late? How's everyone doing? I'm here for court for my sister, DeJoya Gray. Am I in the right courtroom?
Yes.
Yes, ma'am.
Okay.
Let's see. Hold on 1 second. No, first page. All right, I'll go ahead and get started. All right, good afternoon. Let's see, where's ASG's? There we go. All right, thank you. Good afternoon, everyone. We're going to begin our Fulton County State Court Expedited Accusations calendar. And this is a calendar for cases where individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are going to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I think everyone has heard that the SAP reset date for those who don't bond out will be May the 1st. And I want to begin by reminding the defendants on this calendar that you do have certain constitutional rights. The first being that you have a right to counsel at this juncture, and you should know who your attorneys are by now and have spoken to them, hopefully. Also, you have a right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be used against you. The state is here and they're listening. So again, follow the lead of your attorney. All right, who do we have first, deputies?
position number 7, Miss Houston.
Position 7 is 25 CR 002006F. It's Sante Houston, charged with 1 count of criminal trespass and damage to property.
13, 2022 trespass conviction. 2017 battery DV disorderly conduct conviction. 2017 ag assault was reduced to battery DV conviction. 2016 battery DV dead docket and 2011 battery DV conviction.
All right, state.
Good afternoon, Your Honor. Brooke Harrison for the state.
Okay.
This offense occurred on December 1st, 2024. Officers responded to a call at the location, of 904 Trestle Tree Court Southeast. The spelling of that is TRESTLE. Officers responded to a call placed by the victim, Ms. Diamond Houston. Ms. Houston stated that she got into an argument with her mother, who's identified as the victim. She said that the defendant lives with her. The argument was over money to be paid for rent. They got upset with each other, and the defendant picked up a bat and broke the light on the ceiling. We were unable to speak with the victim today, but we are aware that the defendant has a prior criminal history. As such, the state's recommendation is a signature bond through pretrial services. We're asking for no contact with the victim, a stay away from the incident location, and requesting bond conditions of no alcohol, drugs, or weapons while on bond. And we would like to sound for the victim at this time. That's all for the state.
All right, is the victim here, Diamond Houston? Go ahead, PD. Chataya? Okay,
Yes.
thank you.
Correct, Your Honor. We don't object to the state's recommendations, Your Honor. However, if that is my client's current address, I would object to a stay away.
Do we have any information on the address?
I do not, Your Honor, no.
Well, I want to make sure that the victim is going to be safe. How old is the defendant?
See, the defendant is 49 years old, Your Honor.
Your Honor, the state does have concerns about the victim's safety. She stated in some arresting documents that her and her mother have a tumultuous relationship, and she wanted her to stay away.
All right, I will grant a $2,000 signature bond through pretrial. I will also order a stay away from the incident location. No further contact with the victim. No drugs, alcohol, weapons, or guns while on bond. And I believe that's it. I don't know, does she need a one-time escort possibly to go back to that location to get any personal belongings? I will grant that one-time law enforcement escort. Do not go back by yourself, Ms. Houston. And that'll be the order of the court.
Level 2.
I'm sorry, level 2.
We're gonna do add-on position number 2, Mr. Gallardo.
Good afternoon, Judge. It's Joshua Schiffer on behalf of my client, Andy.
All right, good afternoon. How are you?
I'm good. Little surprised to be, well, not really surprised. Yesterday, Mr. Gallardo and I were up in a municipal court handling a very minor ticket when they made him aware that there was a warrant from Roswell that is this case. We kind of maybe thought we might know what it is, but now I've read the warrant. So, Mr. Gallardo, it is that you are being accused of 2 counts of simple assault, family violence for allegedly waving a firearm at, near, or around your cousin, which allegedly placed them in fear of harm. Hence why Judge Drake granted the bond to the complainant. Judge, as I understand, he is already being approved for a pretrial bond, level 2. We would ask a couple of things. Number one, this is a cousin, so that does not fit within the Family Violence Act of Georgia, which requires a closer degree of relativity. So that would need to be amended to just regular old simple assault, not family violence. And we would ask that he be granted a signature bond. These are non-residents with him. They were visitors at his house. We expect to put up a strong defense. And we would ask that that signature bond just be granted. I'm not quite aware what level 2, level 1, level 3, all that requires. But Mr. Gallardo has attended court. He totally would have dealt with this. I don't think he's going anywhere.
All right. This is your case, ASG Allen?
It is, Your Honor. The family violence designation is not because they're cousins, but because they used to live in the same household. The victims have since moved away from that location. They were living there for a period of time with the defendant. It's 2 counts of simple assault and 1 count of pointing or aiming a firearm. We would be asking for a signature bond. This young man has very little to no history. And we were asking that they have no contact, that Mr. Gallardo stay away from that location, and have no drugs, alcohol, or weapons.
All right.
We have no, I'm sorry, Justice Kitty is bothering me. We have no objection to no contact with the, no problem with that, bad cousins. The location, though, is, I believe, Mr. Gallardo's house, and the complainants have no other business to be there. So we would ask that the stay away.
Yeah, we don't need to stay away. The individuals who are the victims in this case have since moved from the location. We just want no contact and no drugs, alcohol, or weapons.
Okay.
I don't have an objection to that, Judge. That sounds very reasonable. And
Sounds good.
we would just ask, though, that it be a straight signature bond and allow him, he will be retaining me and we will be handling this.
I'll have to, because of the family violence, I think that's a restricted. I have to bring it through pretrial, not the jail. State, right? Because of your family violence portion.
Correct. Correct.
Okay. And so level 1 and 2, this is the matter of times they report.
Okay. As long
During
as
the
it's
month.
just the report, he's fine reporting. He lives in town. He lives here.
Right. And I will, let's see, first charge, simple assault, 1,500, SOB trial. Second simple assault, the same, 1,500 SOB pre-trial. And then the third, pointing the pistol, 3,000 SOB pre-trial. So it's a total of 6,000 SOB pre-trial. I'm going to put him at a level 1. And then no drugs, alcohol, weapons, or guns while on bond, and no further contact with the victims in this case. And I think that's it.
Your Honor, we did have a chance to speak to Mrs. Kenya Segura Vargas today. She did report, like I stated earlier, that she and her boyfriend, the other victim, had moved out of the house and now live in Texas, so they're not in the same state. And she wishes to have no contact. If you'd sound for her, Mrs. Segura Vargas.
Anyone on the Zoom by that name, please? Nope, I don't think so.
Thank you.
All right. Anything else, Attorney Schiffer?
No, Your Honor, other than that, it's great to see you. It's been way too long.
A long time.
I have one of my favorite stories when we first met 20 years ago that still makes me laugh. And Mr. Gallardo,
Yes.
Mr. Gallardo, you will be receiving a signature bond. It will take between 6 and 24 hours for you to check out of the jail. You understand all of the requirements that Her Honor has placed on you. As soon as you get out, you are to contact my office and we will take it from that point. Do you understand that, Mr. Gallardo?
Yes, sir. Thank you for all your help today.
Absolutely, sir.
All right.
Thank
All
you.
right. Have a good one.
Thank
All
you
right.
all. Have a
All
wonderful
right.
day.
Bye-bye. You too.
Number 3, Daniel.
Okay. This is 25 CR 00201 SE Demetrius Daniels, charged at 2 counts of battery, family violence, 1 count of simple battery, family violence, and a 4th count of cruelty to children in the 3rd degree.
Tenth
Pre-trial.
arrest. Got an open case out of Alabama, receiving stolen property. a DV harassment case, sale of marijuana, well, possession of marijuana. Wanted out of Clayton County, 2023 battery against a female who was pregnant. I think that was DWAP. 2020 theft by receiving obstruction, 2019 FTA, and a 2017 trespass conviction.
All right. State.
Pamela Westman for the state. Yes, on February 13th of this year at 5401 Old National Highway in Atlanta, the victim, in this case, Kadeja White, said that she and the defendant had had a prior verbal dispute about their child. She was visiting her friend, Miss Arthur, and the defendant repeatedly called her friend while they were at Miss Arthur's home, which is in the same apartment complex. The defendant told her at some point in one of those calls that he wanted the victim to get their child's belongings. So they went to his apartment and into the bedroom to get the belongings. The defendant then stood in front of the door. So the victim, Miss White, her child, and friend Miss Arthur were all in the bedroom. And that's when the defendant blocked the door and said, "No one is leaving until I get my son." Miss White, the victim, stood in front of her friend who was holding her child, known as KKC, and she was trying to protect them. The defendant then grabbed her, pushed her into a mirror. She fell into the wall and hit her head. The defendant then kept grabbing her hair to get to the child. He wouldn't stop grabbing her hair until Miss Arthur, the friend, told the defendant she was going to call the police. And that's when the defendant ran out of his own home. And the witness, the victim, Miss White, and their child, their child KKC, went to Miss Arthur's apartment. When officers arrived, they saw redness and swelling to Miss White's right temple, and Miss White was complaining of neck pain from her hair being pulled. So the two share a child, but they don't live together. As for the arrests, as was stated, the 2023 case was an assault on a pregnant woman. That case was dismissed at trial when the victim was not in court for trial. And again, there was an FTA in Henry County, a felony drug arrest in 2020 that was dismissed, a probation violation in Henry County in 2023, and a criminal trespass in 2019 in Henry County. You know, based on the severity of what happened and the concern for the family, the state is asking for a $5,000 surety bond, no further contact with Miss White, a stay away from Miss White's home and workplace, family violence intervention program, anger management, no alcohol, drugs, or weapons. And we would sound for the victim, Miss White, in this case, Miss Kadeja White.
All right. Miss Kadeja White on the line. All right, ma'am, do you wish to address the court today? Yes or no? Can't hear you. You're still muted.
Okay, can you hear me?
I can hear you now.
Yes, ma'am. How you doing? I'm
Hold on,
Kadeja
hold on,
White,
hold on.
and I was
Hold on.
just coming in.
Ma'am, hold on. I need to swear you in first. First of all, I ask you a yes or no question. Do you wish to address the court today?
Yes.
Okay, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, put your hand down for me. Are you in fear of Mr. Demetrius Daniels?
No, ma'am.
All right, do you want to have any further contact with Mr. Daniels?
Yes, ma'am.
All right. And the child in this case is Mr. Daniels the father of that child?
Yes, ma'am.
Okay. And were you all still living together?
Yes, at the time me and him was living together, yes.
Okay. That was in this looked like this incident was February 13th.
Yes. Yes, ma'am.
And did you all continue living together after that date?
Yes.
All right. Any last thing that you were trying to state?
Yes, ma'am. I was just stating that they have the whole report wrong. At the time of the incident, me and Mr. Daniels was actually together, and Miss Arthur, she she was one of my friends, and she came out over there, just involving herself. It was just definitely just a dispute. No one even put hands on each other. So I'm not sure why they said anything about, swelling to my face or anything. The most only thing I had was a scratch, and that was due to the fact of me and her getting into it. So I just wanted to say I'm not in fear for my life. And I don't think that, he should be even arrested on those charges, because those are serious charges and we're not in any danger or harm's way. So I just think that he should, definitely get a bond so he can get out and be with his
Hold on a second. I can't talk to you if you're walking. Court, so you have to be sitting down.
Okay. Yes, I just think he should go ahead and definitely get a bond so he can be out with his family and go ahead back to work and stuff like that.
Right. All right. Let me hear what his attorney has to say.
Thank you, Your Honor.
Okay.
Let's see, I asked this court to consider a surety bond within the $1,000 to $2,000 range. But in light of the alleged victim's statements just now, I'd also like to ask the court to consider a signature bond. Mr. Daniels is 26 years old. He has lived in the state of Georgia for the past 15 years. He has a GED, and for the past year, he has worked at an H&M warehouse in Stockbridge, Georgia. There, he drives forklifts and he works with packages. He does transport work. For those reasons, Your Honor, I ask the court to follow my recommendation.
All right. Mute yourself for me, Ms. White.
Your Honor, if I might, there's also a charge of third-degree cruelty to children based on this child witnessing this, and they're, and the officer, we know how these cases go, and I'm concerned for the child. So I am definitely going to ask for no violent contact for both the child and the witness, the victim.
Okay. I guess my concern is the February date, and I know there may have been some delay in his arrest. And I usually say, I want to make sure there's been the cooling down period between the parties and not allowing them to immediately go right back to a tense or volatile situation. And I guess with the defendant, does he have somewhere else to go stay, if you know, Mr. Chataya?
Your Honor, my client just informed me that Miss White doesn't live with him anymore, so I thought it would be okay if he stayed at the address that he provided, and that's on the booking sheet, the 5401 Old National Highway, apartment 826. That was my understanding. So if a stay away is requested, I would be objecting to it, since they don't live in the same space.
Your Honor, the reason that state would articulate for a delay in arrest is that the defendant fled the scene. Warrants were taken out, and he was just picked up on the February warrant. He was actually picked up in Alabama as a fugitive from justice. He's got a failure to appear in Clayton County that he had active when he was picked up for this. In Alabama, he was picked up and served with this open warrant and the issue out of Clayton County. And he has a prior simple battery, family violence in this office that was just dismissed because the state was unable to find the victim and bring her into court. I would note that we hadn't spoken to the victim, although we tried earlier today. And the statements that she's making in front of the court about how the report is wrong and she doesn't know why anybody would have been arrested and we got it all wrong. I have perfect, respect and understanding for the fact that that might be her position today, but it was not her position in the police report or at the time of the incident on February the 13th. And to argue that I don't know how to read and our staff doesn't know how to read and that we somehow took out a warrant. We're following through multiple steps. Somebody has articulated probable cause in front of a judge, warrants were obtained, and statements were taken, and there were multiple people present during this incident. So those are the reasons why we're asking for no contact, what should be no contact in this situation. There's a young child present that deserves to not have to have this around.
All right, Ms. White, this is not the trial. I'm not going to retract or delete the warrant. It's there. it passed probable cause by another judge. So I'm not gonna go back and drop any charges or dismiss anything. That is what you need to do, is to cooperate going forward with that. So that's not what my purpose is today, per se. It is to determine what his bond will be and to make sure that he obviously will come back to court. And he's got some FTAs on there that I don't like hearing, because that tells me that he may not return, or he doesn't have respect for the system. And as a fugitive warrant out of Alabama, where I'm assuming that's where he's from, possibly. Though those are things that concern me, to make sure that he comes back to court in Georgia. So because of that, I'm going to give him a surety bond. Not comfortable giving him a signature bond at all. And I will make that a $5,000 surety bond on the 2 battery charges. 1,500, that's 3, 1,000 on the simple battery and 1,000 on the cruelty. So that should total 5. And with that surety bond, I'm going to order, and state help me out. I was going to say no stay away if we have a different address for the victim.
If the location, which was the defendant's address per the police report, is no longer his address, then we don't need to stay away from that location. We're just
Okay.
asking for no contact at this point.
Okay. All right. So no further contact with the parties right now. And you'll have to understand that for the safety of the child and yourself. And I did hear you, Ms. White, but right now, no further contact while he's on bond. And he is to, as they requested, to stay away from you right now, to make sure the situation has cooled down and that you and this minor child will be safe. So if his attorney wants to apply to modify that, can do that later. But as of today, there will be no further contact between the two of you. No drugs, alcohol, weapons, or unprescribed medication while on bond. And I believe that'll be it. Anything else, State?
Yes, we would ask for the family violence intervention program and an anger management class, please.
Not gonna order those at this time. That can come down the road a little bit. And that's it. All right, thank you, Ms. White.
ACDC, go ahead.
Good afternoon, Judge.
Good afternoon.
I have position number 5, Ms. Gray, but before we do position number 5, I do have a quick announcement for position number 4, Ms. Florence. She waived her appearance. And is it possible that we can go ahead and still do her bond now? So that way I can let her know what her bond is, or do her case now, I should say.
We usually do them at the end, but I'll go ahead since it's ACDC. I know you all may want to know over there.
Is it a behavioral issue or a medical issue or a mental health issue?
It's combative and MH.
Okay, thank you.
Okay.
You're welcome.
You want to do that one first, or the number 5?
We could do whichever, Your Honor. I'm gonna do them both. So whichever is
Oh,
easier.
both of them are yours. Okay,
Yes.
well, let's do 4 with the waiver. 25 CR 002008F. Looks like Candesia Florence charged at 1 count of battery. Your trial.
4th adult arrest. Got a open terrorist threats and trespass. 2021 simple battery dismissed.
Your Honor, the offense occurred on April 10th, 2025. The location was 2489 Perry Boulevard is Northwest Library. Officers responded to a call in regard to a female who had assaulted a patron. When they arrived on the scene, they spoke to the security at the library, who advised them that a female wearing a black hoodie, white shorts, had fled from the library towards a nearby gas station after she punched a patron. The officers were unable to locate the defendant in the subject location after searching for her. The victim on the scene, Ms. Barbara Ryling, stated that she came to the library to return a library pass. While she was standing at the front desk talking to an employee, the defendant walked by her and then turned around and punched her on the right side of her face. Ms. Ryling had said nothing to the defendant to provoke her to hit her. The security officer tried to keep the defendant, on the scene to wait for law enforcement, but of course she fled. At the time of the incident, the officers observed lacerations on the corner of Miss Riley's eye and swelling to the right side of her face. The incident was also caught on video footage. On April 16th, at about noon, the officers were dispatched to the library as they were responding to a call of the defendant sitting on a bench wearing the same attire as she was on the 10th. The officers approached the defendant. She identified herself and admitted to striking Ms. Barbara Riley in the face on April 10th. We did speak to Ms. Riley. She stated she does not know the defendant and wishes to have absolutely no contact with the defendant. This is the defendant's second offense of this kind, and as pretrial stated, she has an open case open for terroristic threats. That was also an incident where she assaulted a complete stranger. She has multiple prior arrests for assaults on people. In her most recent conviction, she's currently on probation and required to undergo a behavioral health evaluation and follow up with recommended treatment and complete a 12 course anger management program. In light of this, the state wants to be clear that its position that this defendant does pose a threat to the public, and we recommend a $5,000 surety bond with conditions of no alcohol, drugs, or firearms. We would like to sound for Ms. Riley at this time, and that'll be all for the state.
All right, Ms. Riley? Nope. All right, go ahead, PD Chataya.
Thank you, Your Honor.
Hello, I'm here.
Oh, I'm sorry, where are you?
Can you hear me, Your Honor?
I have to see you.
I thought I had turned my camera on. Give it just a second. It's trying to load.
Okay.
Well, I'm not sure why it won't start.
Yeah, this is open court.
Let's
I
see.
cannot let you speak
Oh.
without. I think it's coming. Is it Barbara Railing?
Yes, this is me. Hi.
I can't see you still. Now, there we go. All right, and you want to address the court today briefly?
Yes, I would.
Raise your right hand for me so I can swear you in first. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, put your hand down for me. Are you in fear of Miss Florence?
No, I'm not at this time. I went to the library. I don't frequent that library very often. They had seen her in the past at that branch and subsequent, which is where she got picked up yesterday. But I don't go to that branch very often. I am
Okay.
concerned, as state mentioned, for the fear of others because the violence was so random. I had contact with her, had never seen her, and out of the blue, she just rushed me and punched me.
All right, thank you for that. And so obviously you don't want to have any further contact with her, is that correct?
Correct.
Okay. All right, any cross-examination by the state or the PD?
No, Your Honor.
No, Your Honor.
Okay. All right, thank you for that. You can stay on to hear the ruling and just mute yourself, and thank you for your time. Okay. All right. Go ahead, PD.
Thank you, Your Honor. I'd ask this court to consider a signature bond instead. According to the Public Safety Assessment Report, my client has no violent convictions, nor does she have FTAs. She's 21 years old. She is a lifelong resident of Georgia. Let's see. She got through school as far as the 8th grade, but she went on to get her GED as well from the Clayton County Goodwill Center, excuse me. And most recently, she worked at Burger King for about 6 months in a customer service role. For those reasons, Your Honor, I ask the court to consider a signature bond, but if that's not possible, then a $1,000 surety.
I'm going to order a $3,000 surety bond. With that surety bond, sounds like we need an MH eval.
Yes, Your Honor, we would agree to that.
Okay. Can you prepare me an order for that, PD Chataya?
Your Honor, I spoke with her. She was able to help me in representing her today. I did not have a problem communicating with her, so I'm not sure what the grounds would be for a competency issue or for trying to identify a competency issue or having mental health issues. Like I said, she was able to speak with me today.
So she wasn't combative and had an issue, and that's why she needs to waive her appearance. She didn't do that with you?
No, I was able to talk with her just fine. I mean, the jail guards informed me that she was combative, but I didn't have any problem speaking with her or having her help me with her representation today.
So the request for a mental health evaluation on the part of the state is based on the fact that she can't stop attacking people in public, and she's been ordered to undergo a behavioral health evaluation and undergo 12 weeks of anger management as part of a probationary plea she entered into on like literally a month ago. That involved assaulting someone at the H&R Block because she didn't like that they didn't tell her what she didn't like what they said to her, another stranger. So there, as far as the state's concerned, is a clear issue with mental health. And that's the reason why we're asking for an evaluation at this point. We're not concerned about competency, although that may be an issue at some point, but somebody wearing the same clothes, hanging out at the library, having constant issues, and then assaulting a random stranger after they assaulted a random stranger 2 months ago at the H&R Block raises a red flag. So I'm glad she could talk to you and she didn't have a problem with you, but you just heard from the jail staff that there's an issue.
Right. And if she has not had that prior MH eval, I want to make sure she's getting it now. And I see someone in courtroom 2. Can't hear you.
Oh, I'm on mute. Can you hear
Now.
me?
Okay.
Oh, sorry.
Yes.
The eval that's going to be done in jail is only going to be determined if she's competent. And so if Mr. Shatai is saying that she's able to help him with her case, then that's the only thing that's going to determine what the eval that happens while she's in custody. The MHE that's only determined if she's competent to stand trial. And
There's no BHET that can be done?
we don't do that. They don't do it in the jail. She has to be diagnosed outside. If she doesn't have an active diagnosis right now, the order that the judge will be signing is only for her to determine if she's competent to stand trial. And Mr. Shatai is saying that he was able to speak with her. She answered his questions. And so that's what that eval is for. When we order the MHE, is to determine if she's competent to stand trial. So it sounds like he's saying that.
I'm clear. He's saying he doesn't have concerns about her competency, but maybe I'm mistaken. I'm here every day, and we frequently have people where there's an issue and it's a request for evaluation. Our judges put people on a docket in the next few weeks and ask for a social worker visit with some real information at that point about whether a BHET is appropriate or what's appropriate for this person. Does she have an address?
I'm a social worker that works with Mr. Shatai, so I'm one of the people that will go out to evaluate them. And when the judge asks for a mental health eval, that's determined if they're competent to stand trial. We're not, the jail doesn't do evals where they give diagnosis. So that's something that has to be done outside. So the MHE that you're requesting is only to determine if they're competent to stand trial.
I understand.
But they would not recommend any treatment at all. Is that what you're telling me?
But they would say if she's competent to move forward with her case.
Right.
The MHE is to ask to find out if the person is able to move forward with their case, if they're in the mental state to do that.
So a person who does not have an address, who's hanging out at the library assaulting people, where there's a request for a social worker visit to determine what kind of resources and access to services this person needs, obviously housing. How are we supposed to have a judge order them to go undergo a BHET when we know they're going to get out of jail and they don't have a house to go to, and on their own, they're supposed to just go get those services and get an evaluation?
So That's what you're asking for. MHE is different from a BHET. So if you're wanting a social worker to go see them to see if they want services or if they may need eval, that's different. But the MHE is.
I thought it was real clear the way I said it, but whatever letters I need to say, let's make it happen. Absolutely. Based on the argument I'm making is that there's something wrong, and I'd love her to be talked to see what it is she needs some help with, because it's already been ordered in the case that she's in front of the judge on, and she was just in front of the court February of this year and ordered to undergo this kind of evaluation. So yes, if the words are, we would like a social worker visit to analyze her and see what kind of services she needs, whether it's housing or some kind of resources related to mental health, that is what needs to happen at this point. I'm not concerned about competency. I just don't want someone to be released because we're saying we only care whether she's competent or not, and there's clearly an issue.
And that's something that the attorney has to ask for us to do, because that's what we work with the public.
Okay, I'm going to be done because it really sounds like this is circular, and it seems like there's a lot of effort being made to just act like you don't understand what I'm talking about and you guys don't understand what's being requested.
I think they do. We'll order the BHET, and with the BHET, if they determine that mental health needs to be ordered as well, or there needs to be something, then we'll do that. All right. Thank you. All right. So it's a $3,000 surety bond, no drugs, alcohol, weapons, or unprescribed medication while on bond. Stay away from the Northwest Library. I think it was 2489 Boulevard, I believe, or the incident location.
Yes, sure.
And no further contact with the victim in this case. Ms. Riley.
That's correct.
And she's to comply with any ordered treatment or medication that they may see fit. She's to comply with all that. All right, that'll be the order of the court. Next case we have is 25 CR 002018E. And it looks like, is that DeJoya Gray, charged with 1 count of battery family violence. Pre-trial?
Fifth arrest. 2017 battery, simple battery dismissed. 2015 assault.
All right, State.
Yes, Your Honor. This offense occurred at 2806 Point View Drive, East Point, Atlanta. Officers arrived at the incident location in regards to a call about an altercation on property. They met with the victim, Angelica Russell Dawson, who informed them that she and the defendants are cousins and they live together. She advised that as Ms. Dawson was walking out of the bathroom towards the living room, the defendant struck her in the face and pushed her to the ground. The defendant stated that the victim bumped into her while leaving the bathroom. And the defendant further stated that when she was bumped, she pushed the victim, Mrs. Russell Dawson, onto the floor. At this time, we were not able to speak to the victim in this case. In light of the defendant's prior criminal history, the state is recommending a signature bond through pretrial services and no further violent contact with the victim. We're also requesting no alcohol, drugs, or weapons. And I believe that the parties are still living together, but they're in the process of separating. So we're not going to ask for a stay away at this time. But of course, no further violent contact. And we'd like to sound for the victim if she is present. That'll be all for the state.
All right, and that's Angelica Russell Dawson. Angelica Russell Dawson. All right. Go ahead, PD Chatai.
I have no objections to the state's recommendations, Judge.
All right, I'm going to order a $3,000 signature bond through pretrial. With that pretrial, I guess it'll be a level 1. Stay away from, I'm sorry, no stay away, but no further contact with the victim. Now, I'm a little confused. We said no stay away because there were one was moving out or something. I mean,
Yeah, so we were gonna do no further violent contact. I mean, Mr. Shatai could probably shed some light on this. I had information that one party is in the process of moving out, so I think that they would still have to coordinate some sort of things.
Right, with no, okay, no further violent contact, then I'm okay, but if it was no further contact, there'd be a problem.
Yeah,
So
sure.
let's do no further violent contact. And then no drugs, alcohol, weapons, or guns while on bond. And that should do it.
Excuse me.
Yes.
I'm the sister of DeJoya Gray. That's her
Hold on,
apartment.
hold on.
Okay.
All right. How old is Miss Gray?
27.
Okay. And you're not an attorney, are you?
No.
Okay. So at this point, for the bond hearing, unless you're going to tell me something that will put the victim in peril, this is not the time for her sister to speak on her behalf. I'm not sure what you're going to tell me.
Well, I was
And I
going
would have to
say that.
swear you in first. You just
Okay.
can't come on and say, I need to talk because I'm the defendant's sister.
Okay.
That usually doesn't happen. You need to talk to her attorney, unless there's something just burning that you have to tell me.
Well, who's her attorney?
He's there, PD Alex Chatai. See that above you on the,
Yes, I sent him a direct message, but I guess he didn't get it.
let's see, maybe sometimes it's hard to look when we're on here. Do you see that in the chat?
Let me pull up the chat. Okay. Unfortunately, I don't think I can call her after court, Miss Edmonds, but I could tell her right now. Yeah, Miss Gray, when you get a chance, please call Miss Edmonds. She asked me to ask you to call her.
All right. Does
Right.
she have a number, deputy? I usually don't do this at all. Very improper. Go down to visitation with the jail, I guess, or wherever she's being held. But I normally don't send messages back and forth for the families. Okay. All right. If that concludes this matter, we can move on.
Number 12, Mr. Shannon.
Okay. '25 CR 00212J, Sean Shannon, charged with 1 count of criminal trespass. Retrial.
14. Got an open case out of card for shoplifting, 2 counts. Fulton theft by receiving, theft by shoplifting. It's 25 SC 0000408. Driving without a valid license, theft by receiving. 2 FTAs from 2019, 2014, and 16 armed robbery dismissed.
All right. State.
Ryan Sorrocker for the state judge. Good afternoon.
Afternoon.
So this incident took place April 16th, 2025 at 3393 Peachtree Road, Northeast Atlanta. It's the Fendi store specifically, but it's part of the broader Lenox Square Mall complex. Law enforcement was flagged down by loss prevention officer Denise Parks, that's DENNICE, who reported that Mr. Sean Shannon and co-defendant Mr. Al Slayton, who should be on today's calendar, they're both known shoplifters who were on the property. Loss prevention informed the officer that he had been banned from Simon Properties, so Lenox generally, on May 16th, 2024 for shoplifting. And he had returned. He was arrested at that time. You've heard from pretrial about the numerous theft arrests. There is that open. There are a few presumably open cases out of DeKalb and Cobb for felony theft by receiving, 2 counts of theft by shoplifting, one of which is a felony from 2022 and 2024. And there are convictions in his history for both theft by shoplifting and receiving. Given that the theft was the reason the defendant was told he couldn't return to the property in the first place, in conjunction with the defendant's history of theft, and including convictions and open cases, presumably open cases. The defendant poses a risk of reoffense here. As such, the state's recommendation is a $1,500 surety. No further contact with Al Slayton, his co-defendant. Stay away from the Lenox Square Mall at 3393 Peachtree Road, Northeast, Atlanta, and no drugs, weapons, or alcohol while out on bond.
And is this Attorney McLeod?
Your Honor, good afternoon.
Good afternoon.
I would be asking for a signature bond for my client. My understanding is that he is actually being held in jail on a probation violation warrant, so he's not going to get out anyway. So I would ask the court to consider a signature bond for him.
How old is he, Ms. McLeod?
He's 27, Your Honor.
Work?
Yes, he tells me that he is employed.
And from Georgia?
He is from Georgia, Your Honor. He tells me that he's currently working on getting his GED as well.
And that probation violation, apologies, Judge, is for the felony theft by shoplifting, felony theft by receiving case that he has opened, 25 SC 000408.
All right, I will order a $3,000 surety bond. With that surety bond, no further contact with the co-defendant, Al Slayton. Stay away from the Lenox Mall and Simon Properties. And I don't know if they own other shopping locations or in and around Lenox. But if it's owned by Simon Properties, he's to stay away. He's already on a ban anyway. No drugs, alcohol, weapons, or guns while on bond. And I think that's it. Anything else, counsel?
Yes, Your Honor. The state's recommendation was a $1,500 good bond. My client is really not in a position to pay for a bond, Your Honor. He actually told me that he has a job prospect. I went back and looked at my notes. He's actually not working right now, but has a job prospect.
I will make it 2,500, but I'm not agreeing with the 1,500 with his history, the numbered encounters, and the open cases. I want to make sure he's gonna come back to court.
If I could issue a correction very quickly, that that probation violation was for a theft by receiving conviction from 2023. But the case that I was referencing earlier, 25 SC 00408, is still open. Thank you.
So he has those several open cases. I'll make it 2,500, but I'm not going down any further than that. Okay.
Thank you, Your Honor.
Thank you. And I think
that concludes my business before the court today. May I be excused?
Yes, you may. Thank you.
If I might interject, it might not, Ms. McLeod, there might be a case for you. Your Honor, would it be possible, a point of personal privilege, could I ask for a breakout room to discuss a potential conflict that Ms. McLeod might be available for between my court and a prosecutor?
Between you and the prosecutor? I was getting ready to say, what do I have to do with it? I believe if you said it's conflicted out and allow her to, unless she needs time to interview the defendant.
We've got some policy questions about conflicts, but
okay.
Why I think this really ought to be a conflict.
Okay. All right. Can you put us in a breakout? Is it Mr. Jordan? I don't know who my Zoom master is today.
Well, and any prosecutor that wants to be there is certainly welcome.
What case are we talking about?
SOU or SOU or SOW.
Okay. Myself and Mr. Sirocco, please. Thank you.
Okay.
Thanks. Mr. Chitai.
Ms. McLeod as well?
Yeah.
Yes, she would be helpful.
That's position 14. Thank you, Ms. Grace.
looking for the sign. There we go.
Ms. Bridgewater?
Yes, ma'am.
Okay, just making sure you were there.
I'm here.
Deputies, who are we going to see next? Miss,
Number 6 on the add-on, Mr. Wilson, because I don't even know.
number what on the add-on? I
Yeah.
thought I only had 3.
No, that was 6 add-on.
Huh?
That was a 6th person on the add-on.
Let me look. Yeah, is it Shay or Shy Wilson?
Shay Wilson.
Shay Wilson.
Okay. So that's what we're doing now?
Yes.
Okay, thank you.
Because the other person McLean talking about, I'm not familiar. I don't know who that person is, so I don't know who to call up for Miss McLeod next. Who is the person?
She's gonna try to get an interpreter.
Okay.
Please, can you holler over to Michael? They're getting ready to reach out to Mr. Jordan.
A Spanish interpreter?
Nope, not Spanish. It's deeper than that.
What's that?
Ms. McLeod is familiar with the language.
Wolof
We have
interpreter.
a different language barrier, Miss Lucia. And say it again for me, Miss McLeod.
It's Wolof, Your Honor, Wolof. And I do know that there is a Wolof interpreter because I had a case about 3 weeks ago when there was a Wolof interpreter called in.
Okay, let me reach out to him right now.
In fact, was this, I'm trying to think. Yeah, there was a Wolof interpreter called in on a case I had about 3 or 4 weeks ago.
Okay, give me just a second. I'll be right back.
Yes.
Oh, maybe my add-on was missing a page. So we're on position 6 on the add-on.
Yes, ma'am. Mr. Wilson.
All right.
I have Miss
25 CR 002023 D. Charge of 1 count of criminal trespass and a 2nd count of possession and use of drug-related objects.
Excuse me 1 second, you guys. I am being told we're gonna have to reset that interpreter case until tomorrow.
Sure.
Okay?
Right.
Yes, Ms. Bridgewater, I believe it was a general understanding that it would be reset.
Okay, now what position was that? Is it on the calendar now?
Yes, 14.
14. Okay, gotcha. So we'll reset them.
Thank you.
Okay, so I guess that does conclude my business before
Yeah.
the court today. May I be
I thought you
excused?
may have wanted to hear that. Okay.
Yes,
Thank you, Ms. McLeod.
you're welcome. Have a good day.
Judge, you ready for the history?
Go ahead, yes.
It's 10th arrest on probation for trespass, a couple of them. 2025 FTA, 2024 FTA.
That's my case, Your Honor. This is an incident that happened on the 14th of April. Police were called to it's a strip mall or a complex. It's 1425 Market Boulevard in Roswell. There are multiple stores there. It was reported that the defendant was there on the property, was known to the individuals there who own and run stores as someone who comes in frequently asking to use the phone or asking for money. Police saw him on the property on the 14th and were later able to verify after they told him he needed to leave and not come back. They verified that he'd been told already, and he actually signed documents on the 13th of April telling him he needed to stay away from the entire complex, and his signature acknowledging that. A warrant was obtained for criminal trespass based on that behavior, and then he was located on the 16th of April, and that's the basis of the drug object charge, Your Honor. He was at 1490 Holcomb Bridge Road, recognized as someone the police officers were familiar with, taken into custody, and search incident to arrest. They recovered a drug object, a glass pipe. He just pled guilty in 2 different misdemeanor cases that are criminal trespass. Those are 22 CR 002885A and 23 CR 001-651A. He has not currently being supervised. I believe those are suspended sentences, but those involve the Economy Hotel in Roswell. So we're asking for a $2,000 surety to stay away from the Market Boulevard in Roswell at 1425 Market Boulevard. That whole complex, no drugs, alcohol, or weapons. And we'd ask for a social worker visit to determine if a BHET is appropriate.
All right. PD?
Yes, Your Honor. Shay Wilson is 30 years old, from Johns Creek, grew up around Roswell, I believe. The high school location I don't have, but he's working on his associate's degree with Talladega College, working on a business associate's. Your Honor, he is an entrepreneur. He's an entertainer. He sings. We would ask the court for the lowest bond appropriate. If that's the signature bond, that's super. But if it's not, we'd ask for $1,000. And I will have the social worker talk to him.
All right, I am going to, what was the state's recommendation again?
I'm sorry, go ahead.
It's fine. We asked for a $2,000 surety to stay away, have no drugs, alcohol, or weapons, and we requested a social worker visit. He just pled guilty to 2 open cases that had been open for a long period of time. And it appears that he was offered the opportunity to participate in one of the special courts here, and declined that offer. So we'd request a social worker visit.
All right.
Right, and our recommendation was either free or a 1.
Okay. I will order the $2,000 surety bond. It's based on its history here. Stay away from the incident location. No drugs, alcohol, weapons, or guns while on bond. Was there any contact request?
No, just to stay away from the entire complex there.
Okay, so stay away from the entire complex, assuming he does
Set
not.
1,000
live
on
there.
each.
Yes, 1,000 on each. And I'm assuming he doesn't live there.
No, Your Honor, he's got an address in Alpharetta on Old Maple.
Okay. Sounds good.
Number 6 on the regular calendar, Harris.
Okay. That is 25 CR 0020007F, Jalen Harris, charge of 1 count of SB misdemeanor. Do we need to stop streaming? I don't know what the facts are.
Do y'all prefer to just do him last and I can just go to the next person?
Yeah, let's do them last.
We could do that.
We can do number 8. Come on, sir.
Okay.
Why y'all?
8 is 25 CR 0020005C. Marcus, is it Manigault, charge of 1 count of Lord or Prowling.
On probation for DUI, 2022 disorderly conduct conviction, 2016 probation.
All right.
Your Honor, this incident occurred on November 3rd, 2024. The location is 901 Rice Street. On that evening, Jail Investigations Unit received an alert that the jail security video captured an unknown male suspect who wore a red hoodie, black pants, and white shoes walking along the jail's fence line in the wooded area of the backside of the jail. The video captured the defendant as he walked to the top of the fence line and touched the fence as if he was testing the integrity of a portion of the fence. The defendant continued through the wooded area, jumped the fence onto the Quick Trip property. Deputies then made contact with the defendant, identified him, and arrested him. In light of the defendant's prior criminal history, the state's recommendation is a signature bond through pretrial services, a stay away from the incident location, and we're requesting no alcohol, drugs, or weapons while out on bond.
All right. Go ahead. Is it PD Chataya?
Yes, Your Honor. I do not object to the state's recommendations.
Okay, SOB through pretrial. And then I need to tell them to stay away from the Fulton County Jail. All right. Well,
Your Honor.
I'm sorry.
That won't be happening.
Okay.
What was the dollar amount?
That dollar amount I haven't said yet. I
Oh,
was
okay.
commenting that I'm going to order him to stay away from the jail.
Okay.
I guess that's a good thing. Let's see. What about $2,500 signature bond through pretrial? Stay away from the, what do we say, the fence line or the jail?
The backside fence line, I think.
Backside fence line. Well, I would say stay away from the jail unless you're a resident there. And that I won't have much to do with. But I don't know what he was up to or trying to break someone out, I guess. I don't know. But no drugs, alcohol, weapons, or guns while on bond. And I guess that's it. It's all I can order.
What level?
Level 1.
Okay.
Oh, yeah. Add on number 4, Mr. Kevin Mott.
Okay. This is 25 CR 002020V, Kevin Mott, charged with, do I need to move in? This is it's a PI case. I don't know what the facts are, but he and the other gentleman may need to both be at the end.
Yes, Your Honor.
Number 9 on the regular calendar.
Okay. Mr. Parrott. Okay. 25 CR 002009D, charging 1 count of lawful possession, display, or use of an ID and willful obstruction. Pretrial.
29, I'm sorry, 18, 2020 probation, FTA. Battery DV, cruelty to children, trespass in 2019. 2017 probation. 2014 obstructing police, operating impaired conviction. 2012 simple assault, DV conviction.
State.
Thank you, Judge. This incident took place yesterday, April 16th, 2025, at Peachtree Street and John Portman Boulevard Northeast, where those intersect. Law enforcement observed a vehicle that was parked in front of a no parking sign. And upon approach, the officer met with the driver, another individual, while simultaneously the passenger, identified as the defendant, immediately exited the vehicle from the front passenger seat. The defendant was told several times to step back inside the vehicle, which he refused. He became aggressive. The officer asked the driver to exit the vehicle because he had smelled the odor of raw marijuana, and at which time he observed the defendant get back inside the vehicle. So he went around and then asked the defendant to step out, which he initially refused. Then he complied. And when asked to put his hands behind his back, he refused, said no, clenched his fists. continued efforts to detain him, and ultimately officers had to fall to the ground. They fell to the ground in order to detain him because of his resistance and aggression. After this, he was searched and he was found to be in possession of a fake Georgia driver's license, with a driver's license number that had a different name, Dorothy Williams. That was what it was registered to when it was run, but on the name of the license itself, it stated Kenneth Daniels. The defendant that it actually admitted that he had received the fake license for free. So, with respect to history, Judge, several forgery convictions, one in the third from 2020, one in the fourth, 2017. You have that Michigan conviction for operating a vehicle while impaired and assaulting / resisting / obstructing a police officer from 2015. I also see another arrest for forgery in the third and several violence, though family-related arrests from 2012, 2019. Don't have the dispositions for those. But I do see as well, not sure if this is confirmed, but it looks like wanted out of Michigan for a misdemeanor case. I don't have the details on that, but given that he appears to still be wanted out of Michigan, as far as I can tell, and his prior convictions for forgery and for assaulting, resisting, obstructing, the defendant does pose not only a potential flight risk, but a risk of reoffense here on both charges, or charges of similar nature. As such, the state's recommendation is $1,000 surety on each count. No drugs, weapons, or alcohol while out on bond. That is all for the state.
All right. PD Chataya.
Thank you, Your Honor. My client asks this court for a signature bond, otherwise the lowest surety amount possible. He's 34 years old. He has lived in Georgia for the past 10 years now. Let's see, in terms of his schooling, he finished school, and then he did some college. He did about 2 years of college doing IT. And for the past 3 months, he has had stable employment, helping with evictions. For those reasons, Your Honor, my client asks for a signature bond.
Okay. I'm going to order the $2,000 surety bond. 1,000 on each. No drugs, alcohol, weapons, or guns while on bond. And was there a stay away?
State did not ask for one. This was a traffic stop.
Oh, that's right. You did say traffic. And no victims either. Okay. So that was it. No drugs, alcohol, weapons, or guns while on bond. Next.
Let's do Demetrius Cameron. Y'all. Never mind. Let's go to Reeves, position number 10.
Okay. This is 25 CR 002010Y. Isaiah Reeves, charge of 1 count of disorderly conduct. Retrial.
8 adult arrests. Let's see. We went to felony earlier. $11,000 bond. Stay away from Marta. Wanted out of DeKalb County. He got an open case in DeKalb. Possession of a pistol by person under 18. Disorderly conduct, trespass, theft by receiving, and obstruction.
All right.
Hold on.
Okay. Oh,
He got another open trespass, disorderly conduct, 24 MAGC number. On probation out of DeKalb for terrorist threats. That'll time out in August. And was arrested this year for trespass, disorderly conduct. That's all.
okay. Okay.
Yes, Judge, this incident, it was actually a delayed arrest. This took place on April 1st of this year at 3360 Peachtree Road, Atlanta. It's the Buckhead MARTA station. Law enforcement was contacted regarding an alleged assault there. Officer reviewed the CCTV footage of the incident, which showed the victim in this case, Mr. Joshua Tullis, that's Tullis, walking on a bridge where he was approached by three juveniles, from what it seemed. One of the juveniles pulled out a replica gun. It had an orange tip and pointed it at Mr. Tullis. All three of these individuals ran immediately following the incident. The officer spoke with Mr. Tullis, who explained that as he was walking the bridge, he was approached by one of them who had waved a $20 bill in his face, while the second one brandished, pointed, and actually pulled the trigger of the replica gun towards him, following which all three of these people ran away laughing. The one, excuse me, it was on April 15th, 2025, actually, that police comms received a call stating that three juveniles had attempted to rob a different victim at the Buckhead MARTA station. After reviewing the CCTV, those three individuals there matched the be on the lookout place for this case. Those individuals were detained, and the suspect was identified, the one who actually pulled out the gun, or the replica gun, pointed it, pulled the trigger, was Isaiah Reeves, the defendant here. He was arrested. He does have that pretrial reference, that probation that he was on for terroristic threats and acts. That conviction was 2024. And the open cases out of DeKalb involving a possession of a firearm, disorderly conduct, felony theft by receiving, and then the other disorderly conduct and criminal trespass. But what I want to talk about here is that other open case as well, because he was charged in 25 PI 003018, the way he was arrested here, with criminal attempt to commit a felony, that felony being a robbery, simple battery, and giving false information. In that case, there was a call about three individuals attempting to rob a different victim at the Buckhead MARTA station. The defendant was identified as the one who got in the victim's face, tried to get him to transfer money via Cash App. They all three then antagonized him some more before the defendant then tried to snatch the backpack off of the victim. They then got into a fighting stance, and then after the two had disengaged, the defendant struck the victim in the back of the head with a closed fist. That's that's that other case. I see as well a foreign county hold for the defendant for failure to appear. That one, the date of that is February 19th, 2025. It's one of those DeKalb cases. I'm not sure which one, but in any case, we've spoken with the victim. He has stated that he does not know the defendant, that the three individuals came toward him and confirmed those events in the warrant, but added further that, in addition to tapping him on the face with this $20 bill, one of them, then the defendant actually put the gun to his head before pulling the trigger and hearing a pop. He didn't know the gun was fake. He thought it was going to be fired. And he was in fear for his life. He does not want contact. We would ask that the court sound for him when appropriate. But in any case, given the open failure to appear, his history, including the terroristic threats and acts conviction, other open cases out of DeKalb, and this other open case out of Mora. He poses a substantial threat to the peace and safety of the public. Seems to be the ringleader of these three individuals here, and himself included, that terrorizing others on public transportation, sometimes for money, sometimes just cruel and senseless like here. As such, the state's recommendation is $8,000 surety, no further contact with Joshua Tullis, stay away from all MARTA premises and property, surrender any and all firearms, any and all weapons to the sheriff's office, and no drugs, no alcohol, and certainly no weapons while out on bond. If we could sound for Mr. Tullis.
All right. Mr. Tullis. All right, keep going.
Ready, Your Honor?
Yes.
Mr. Reeves is 18 years old, Your Honor. Bond was set on the 3 card at 2,000 on this, and I understand the state's request to change that. He has an education level in which he is working on his GED right now. He just started working at a restaurant. An 18-year-old is not going to have a 5-year history, which I usually try to get out of him for employment. So he's working at the restaurant and working on his GED. He has a broadleaf 30349, so he's local, has a stable address. He gave me phone numbers. We would ask the court to consider the lowest possible surety bond, if not a signature bond. If the court is not leaning towards a signature bond, then we would ask the surety bond to be a low number if possible. Thank you.
I think I see the victim here, Mr. Tullis.
Yes, ma'am.
And I'm sorry if I overlooked you earlier. Do you wish to address the court today? Yes or no?
Yes, please.
Okay, raise your right hand for me so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right, put your hand down for me. Are you in fear of Mr. Reeves?
Yes.
Do you want to have any further contact with him?
No, ma'am.
Okay. All right. And I understand, I guess with this it was, and I'm looking at it random, correct?
Yes, ma'am.
Okay. At the MARTA station. Okay. And they have it on video, is that right?
Yes.
Okay. All right. Any cross-examination questions?
No, thank you, Your Honor.
Okay.
None from the state. Thank you for being here, sir.
Yes, thank you, sir.
Thank
You can mute yourself and then continue to listen to the order. All right. Mr. McLean?
Nothing further, Your Honor.
Okay. All right. Due to the severity of the allegations and the history as well, I'm going to order the $8,000 surety bond. And I understand he's young, but we want to make sure that we don't see him again, hopefully. And I think this is interesting. He just got up and walked away. That probably shows his attitude. $8,000 surety, and stay away from, well, does he have a band already for MARTA or no?
Yeah, they gave him one in felony.
They did give him a ban in felony. Okay. All right. So he's to comply with that ban, stay away from all MARTA. No drugs, alcohol, weapons, or guns while on bond. That's it.
Good afternoon. How everybody doing?
Good afternoon.
I get a breakout room between myself and Spanish interpreter and whoever's Mr. Martinez's attorney.
Okay.
Good afternoon, Your Honor.
Good afternoon. How are you, Miss Lucia?
I'm doing well, thank you, Your Honor.
Good.
Who's the attorney for this Spanish case?
Mr. McLean, is it you?
I think that's going to be Mr. Chitaya.
Oh, Mr. Chitaya.
What was the name of the defendant?
Right.
It's Luis Martinez Diaz.
Yes.
That's your case, Mike.
Oh, okay. Very
But
good.
I can take him if you'd like. I can interview him.
No, I'm prepared on everything else, so I'll just go ahead and do Diaz. That's fine. Martinez Diaz. Let's see. There we go.
What position is it?
So we,
Position 3 on the add-on.
well, we got two people left for Mr. Child, and then with the rest of them are from Mrs. McLean, so we might have to go ahead on and do these two for Mr. Child. We're gonna have to do Mr. Harris, I'm gonna have to keep waiting.
Okay, well, let's do those.
I'm gonna clear the courtroom just for these. Come on, y'all, just step out the room.
Thank you.
Okay.
We'll be back in shortly.
All right, and which position is this we have now? This is. All right, we have before us.
This is Harris, position 6.
Okay.
Okay. For Mr. Harris, Your Honor, I ask if instead of reading out the charge, if we could read the initials of the charge.
All right.
Or an abbreviation, and also if we could waive reading of the essential facts.
Well, what we usually do, Miss Grace, is you stop the live stream, but we have to record. Can you hear me, Miss Grace?